from asserting the lack of consideration as a defense. Okay, so it's just a very quick question, right? So promissory estoppel is similar to what doctrine that we have studied before? Can anyone think of a doctrine, a doctrine that we studied before that somehow, not 100%, but somehow similar to promissory estoppel? We have studied this in class and explain why. Again, right? A doctrine that is similar to the doctrine of promissory estoppel that we have discussed in class. And please explain why you think they are similar. They are similar in some ways, not everything. There are some in common, and there are some there are some differences. If you have the answer, feel free to raise your hand on the chat raise your hand, and I will call your name. Okay. Nobody? Okay, so my hint. Remember doctrine of quasi-contract that we discussed before? When we study categories of contract, we discuss implied law contract, and there's something, or sometimes we call it quasi-contract. So what is the similarity or differences? What are the similarities and differences between promissory estoppel and the doctrine of promissory estoppel and the doctrine of quasi-contract? Can anyone please compare and contrast promissory estoppel with the doctrine of quasi-contract? Right, so to save time, in both doctrines, right, a court would impose a contract obligations on the parties to prevent unfairness, even though no actual contract exists. Right, that is the similarity. And what is the difference? The difference is that with quasi-contract, no promise was made at all, right? And in contrast with promissory estoppel, a promise was made and relied on, but it was unenforceable, right? So a quick comparison for you to see, to link you with another concept, right? So it's easier for you to remember both doctrines, right, later on when you need to apply into a case scenario, or when you need to do any short answer question. Right, so let me give you an example of promissory estoppel, right? An example of promissory estoppel. So, ABC, okay, is a company. And ABC request bids from a subcon got bid for bid for to build, which is a bid to build, right? And okay, and X, right, is a plumbing subcontractor, whatever, just a sub for the plumbing work, right? And maybe X information answer ABC actually won, right? And however, X actually plans to withdraw right? The doctrine of promissory estoppel prevents X from withdrawing its bid because why? Because ABC was awarded the contract based partially because part of the building is to do the water upon X, right? So therefore, of course, if X draw its bids, so it's gonna affect B's bid, right? So the bids doctrine of promissory estoppel already. Okay, so and therefore allowing X to withdraw from the contract would cause some interest, right? So this is an example for promissory estoppel. This one actually in your textbook, but just in case you don't read, so I just repeat to you again. Okay. Any questions so far, everyone? Okay, otherwise let's move on. Before we continue, since we have many students here in class already, so I would like to ask, since we did not have class on Tuesday, right? And I said to yeah that we will decide and make up, we will arrange and make a class. So this is my suggestion from 18th. Do you have class in the morning? From 7. Let's do from 7 to 10:30. Ah, okay. Is it better now? Yeah, is it better? Can you guys hear me better now? Okay, good. Right, so okay, so sorry, I don't know why it's logging out. So March 18th, Friday, from 7 to 10:30, we will have a makeup class. Does it work for you guys? You get any class on that Friday?
We have class in the evening.
Ah, okay, so morning is fine, right?
I'm not very sure that maybe we should, my class maybe need to discuss about that.
Okay, so nghe could you please have I don't know, the vote, the poll in your class to decide if March
Recording in progress.
18th, right, from 7 to 10:30 a.m. works for you. Okay, so can you please do a quick you can just ask your classmate right now, and then please get back to me by the end of this class. Is it okay? And if that time works for you, that will be also your midterm exam day. Okay, that will be the last day of class. Will be the day to do the midterm exam. Okay.
Okay, sure.
Yep. Yes. Thank you. Yeah, I believe you guys have a group, so maybe you can just ask the whole class if today works, and we decide that, confirm that today by the end of this class. So you have like a week to prepare, right? Which is not a big deal though, because it's going to be a group discussion, so it shouldn't be a problem. Okay. So let's move on. So we're going to move to the next element, right, for contract reality, right, in addition to agreement and consideration, right? So, which is contractual capacity, right? What is contractual capacity? That is the legal ability to enter into a contract relationship. And usually, right, court will presume that the existence of contractual capacity of the parties as entering into a contract.
Recording stopped.
So, okay. And historically, the law has given special protection to those who bargain with the unexperienced of youth, or and those who lack a degree of mental competence according to the law. A person who has been determined by the court to be mentally competent, for example, right, and cannot form with another party who is completely competent, right? And now we're going to look at the effect of youth, right, intoxication, and mental incompetence on contractual capacity. The first one, right? Minors, right? So today, in most states in the U.S., the age of majority, it means when the person is no longer a minor, a kid, right, for contractual purpose is 18 years. Right? However, of course, if you tend to drink alcohol, to consume alcohol, then the age is still 21. Right. In addition, right, some states actually provide for termination of minority on marriage. That's a different story. So, and the minor status may also be terminated by a minor's emancipation. Right? What does it mean, emancipation, guys? Anyone knows this word? Right, so emancipation means when a child leave the house, right? They're not under the protection of the parent, legal guardian any longer. Okay, so usually gonna be like if you explain it in the very technical term, it would be when a child's parents or legal guardian relinquishes the legal right to exercise control over the child. Right? Then maybe when they leave the home to support themselves, or like for example, if the minors themselves make a petition, right, to the court for emancipation, right? And for example, if you are a singer, right, you are very young, you are the age, right, and you would like to do business, you want to be a singer professionally, right? Then you may petition a court to be treated as an adult. Okay. The general rule is what? The general rule is that the minor can enter into a contract, any contract the adult can, except the contracts prohibited by law for minors, like the purchase of alcohol or tobacco, right? And a contract entered into a minor, however, is avoidable at the option of a minor, right? I mentioned minor and avoidable before as we study categories of contract. Right? So to exercise the option to avoid a contract, a minor need not only clearly show an intention not to be bound by it, right? And the minor avoids the contract by what we call disaffirming it. Okay, disaffirming. So we get used to the term disaffirm or disaffirmance. Okay. So what does it mean when we say disaffirmance? Right, let's look at that word first. What does it mean by disaffirmance? Disaffirm or disaffirmance? Disaffirm is a verb, disaffirm is a noun. What does it mean? What does disaffirmance mean? So disaffirmance is actually a legal avoidance or setting aside of a contractual obligation. Okay, and to disaffirm, a minor must express his or her intent through words or conduct not to be bound to the contract. Okay, and the minor must affirm the entire contract, not merely a portion of it. Right? For example, the minor cannot decide to keep part of the good purchased under the contract and return the remaining good. So if you don't want, you want to you want to set aside the contract, then you have to set aside the whole contract. It's like you buy 5 things and you want to cancel the whole order. If you want to set aside a contract, you have to give back the whole order. You cannot say, "Oh, I wanted 2 and then I give back 8." Okay. So now let's look at some key issues related to minor. We have Infancy Doctrine, Ratification, Parents' Liability, and Necessaries of Life. Okay. The Infancy Doctrine, as the name suggests, right? The Infancy Doctrine gives minors the right to disaffirm most contracts that they have entered into with adults, right? This is based on the public policy to protect minors, with the reasons that minors should be protected from the unscrupulous behavior of adults. Okay? Of adults. So under the Infancy Doctrine, a minor has an option of choosing whether to enforce the contract, right? And the adult party is bound to the minor's decision. If both parties to the contract are minors, both have the right to disaffirm the contract. This one is similar to what I mentioned before. So, and disaffirmance must be done within a reasonable of time. Okay, must be done within a reasonable time. Right, and a contract usually can be disaffirmed at any time during minority, right? Or for a reasonable period after reaching the majority, right? And again, what constitutes reasonable may vary, right? Because we studied that many times before from the beginning of the course until now. So if an individual fails to disaffirm an executed contract, right? Remember the concept, executed contract. What does it mean, executed contract, everyone? What does it mean when we say executed contract? What is an executed contract?
Miss, I remember that executive contract is the contract that is fully performed by both parties.
Yep, thank you. Right, an executive contract and so is a contract that is fully performed by all of the parties to the contract, right? So in this case, if an individual fails to disaffirm an executive contract within a reasonable time after reaching the age of majority, the court will likely hold that the contract has been ratified. Okay, we will discuss ratification shortly. Okay, so please remember that. Next one. Okay, the party's duty upon disaffirmance, right? The obligations, right? Even though all the states permits minors to disaffirm the contract, states differ on the extent of the minor obligations and on disaffirmance, right? And most states hold that the minor need only return the goods subject to the contract, right? Provided the goods are in the minor's possession or control, right? Even if the minor returns damaged good, the minor is often entitled to disaffirm the contract and obtain the full refund of the purchase price. Okay. However, if you look at the slide according to the textbook, right, the minor has the duty of restoration. Okay. Means what? It means that the minor is obligated only to return goods or property he or she has received from an adult in the condition it is at the time of disperformance, even if the item has been consumed, lost, destroyed, or has depreciated in value by the time of disperformance. Okay. How about the competent party duty? Okay. If a minor has transferred the consideration, right, to the competent party before disaffirming the contract, that party must place the minor in status quo. What does it mean? It means that the minor must be restored to the same position he or she was before the minor entered into the contract. Okay. And if the consideration has been sold or has depreciated value, the competent party must pay the minor the cash equivalent. And this action is called the competent party's duty of restitution. Restitution and restoration. Please don't confuse these two words. Okay. If you don't understand it, or if you think that you need to have more time to digest it, please look at the textbook. Right, they say it very, very clearly. Some parts that I actually repeat the textbook because I'm not sure if all of you read the textbook. Okay. So as I'm saying, that I mentioned before, courts in a growing number of states place an additional duty on a minor to restore an adult party to the position he or she held before the contract was made, right? And the court may hold a minor responsible for any damage, ordinary wear and tear, and the depreciation of the goods that the minor used prior to prior to this performance. Okay. So, however, there are some exceptions to the minor rights to disaffirm. The first one is misrepresentation of age. So, ordinarily, minors can disaffirm a contract even though they misrepresented the age. Right? For example, you buy to say that you're 21 years old when you were not. Right? However, right, a growing number of states have enacted law to prohibit disaffirmation in these situations. Okay? In some states, misrepresentation of age is enough to prevent disaffirmance. However, in other states, disaffirmance is prohibited. Disaffirmance by minors is prohibited if that minor misrepresented the age as engaging in business as an adult. Right? And another one which is necessary, is which one we will discuss later on. The next one we will discuss is ratification, right? What does it mean by ratification? It is the act of accepting and giving legal force to an obligation that previously was not enforceable. Okay, and when a minor has reached the age of majority, he or she can ratify a contract expressly or impliedly. Okay, and if a minor fails to disaffirm a contract within a reasonable time after reaching the age of majority, then the court must determine whether the conduct constitutes ratification or disaffirmance. And generally, the court will presume that executive contracts fully performed are ratified, and executory contracts not yet fully performed by both parties are disaffirmed. Okay, so this is why the concepts, the previous concept that we studied, really important for the later, for what we're studying right now, because uh, the latter one will be built upon the previous knowledge. And now we discuss a lot of it, we discuss executive and executory contracts a lot, right? So I think there's I have been speaking since the beginning of our class, so let's look at some examples. So we look at two. Number one, A, 16 years old, bought a truck. Okay, let's say bought a car, so it's easy for me to draw. Okay. From B, right? Bought a car from B. It's a used car dealer. It's a used car dealer, right? Even though the car develops some mechanical problems, 9 months later, A continued to drive until it stopped running, right? And then A actually disaffirmed the contract and attempted to return the truck to B for a full refund. Okay, right. Can you see the whiteboard right now? I thought, okay, good, thank you. Right. So A is 19 years old kid, and A bought a car from a used car from B. B is a dealer, right? Used car dealer. So, and the car has some problem, mechanical problems, right? 9 months later, A continued to drive it until the car stopped running. And then A disaffirmed the contract and attempted to return the truck to the dealer and to get the full refund. And the dealer refused to accept the car and refund the purchase price. And A actually sued B. A actually sued B. So if you were the judge in this case, what would be your decision? Okay? What would be your decision? Example number 2. Lisa would like to sell a laptop, right? Laptop to Andy, right? Andy is a minor, right? Andy is a minor, and there is 2 scenarios, right? So number 1, A, if on reaching the age of majority, right, Andy email Lisa and say that he still agreed to buy the laptop. What is the legal term of Andrew action? Okay, and B is that Andy continue takes possession of the laptop as a minor and continue to use it well after reaching the age of majority. What is the legal technical term of Andy's act. Is it clear, everyone? So instead of saying like very, so if we need to find in exercise in the scenario number 2, we need to look at the legal terms. Actually, there are 2 cases. The legal terms for Andy's act. Okay, again, Lisa enters into a contract to sell her laptop to Andy. Right? Andy is a minor. So A, if on reaching the age of majority, Andy emails Lisa saying that he still agreed to buy the laptop, how do we call Andy's act, right? Using the legal term. And if instead Andy takes possession of the laptop as a minor and continues to use it well after reaching the age of majority, what has he actually done, right? A legal terminology or the legal terms of Andy's behavior or act, not to use behavior, act. Okay, is it clear? Do you have any question for these 2 examples? Okay, if you don't, so maybe I'll break you guys into smaller groups. Okay, so you can work with each other, maybe 3 groups, and you can choose again the people to work with. Right? I will give you, let's say, I think 20 minutes should be enough. Go over them together. Maybe 4 groups. And I will ask each room to please, how can I say, have 1 representative to share their answer. Okay, so make sure that you have an answer. So it is 1:32 right now. We will go over the exercises at 1:52. Okay, so what would be, let's look at example number one first, case number one. So if you were the judge, how would you decide this case? What do you guys think of exercise number one? I mean, example number one, whatever you call it. In number one, if you were, this is so, if you were the one who decide the case, how would you, who is the winner in your case first, A or B? A or B is the winner, guys. The basic question first. Just let me know, because like this kind of question, this kind of example is going to be very similar to those that you will see in your midterm or your final. Okay. These two examples to illustrate the points that we have just discussed before, from the beginning of the class to now. So if you were the if you were the judge, a judge to this case, what would be your decision? I will be the winner. Okay. Can you please explain? So if my question were in the exam, right, or if the exam question by whoever gave it, right, if you were the judge, how would you decide the case? So besides saying that you would rule in favor of A or B, right, you have to provide the reason, the rationale, right? All right, so Nghe, you think that, or your group will think that A will be the winner. Can you please support your idea?
Yes, we come to a conclusion that A will be the winner based on the Infancy Doctrine.
Mm-hmm.
So because A is the minor, he bought the car from B when he was 16 years old, and 9 months later he had a car accident. He want to disaffirm the contract between he and B. So we, based on the duty of restoration and the duty of restitution, concluding that A will return the car to B, and he will be restored to the same position he was in. He was before entering the contract. That is, B will return the money to A, so that A will be the winner.
Okay, thank you. Yep. Something to clarify, I did not have an accident. There was something wrong with the mechanical problems of the car. The car had some mechanical problem. However, A continued to drive it until it stopped running. There was no accident. Like you have a car and you knew that something was wrong, but you didn't care and you keep running the car until it stopped working. That's it. So there was no accident. Can you hear me well? Yeah.
Yes, I understand.
Yes. So if that is the case, it was not there was no accident at all. I knew that the car developed a mechanical problem, right? And however, I still continue to run it. So does it change your answer? So it means that, for example, if A paid B, let's say 2,000. So now A gonna give back to B, have to give back to A 2,000, right? That is your answer, if I'm not mistaken.
Yes, B had to give back to A 2,000.
Okay, all right. So if, because maybe when I say that the line was not clear, so you thought that it was an accident and the car stopped running. So in this case, there was no accident at all, right? The car stopped running because it developed mechanical problems, but I ignored it and continued to continued to use it, and until it stopped running. So does it change your answer?
Yes, it does.
Okay, so how? Why? Can you please explain?
So we will base on, sorry, give me a second.
Sure. Yeah, just please think. Anyone else? Why Ngày is thinking? Anyone else from other group, please? Take your time. Anyone else?
We will base on the minor's duty of restitution because so that A will have to put B in status quo upon disaffirmance because A's intentional or grossly negligent conduct caused a loss to the car of B.
So
that A will pay back the money.
A will pay back the money.
A will
Ah.
lose the case.
I will lose the case. Okay, thank you. Right, good. Thank you. Anyone else sorry. Let's hear from others. Any other thoughts? Okay, so Nghe Nghe and the team member and her team member, I agree with the answer, right? So if I were to judge, right? If we were to judge, right, we should allow the minor to disaffirm the contract, right? However, because he knew of the car's problem and continued to drive it until it stopped running, right? So therefore, we should require the A to compensate the seller for the depreciated value, right? Not the purchase price of the car, right? So he should be responsible for that because, like as I mentioned previously, courts in a growing number of states place an additional duty on the minor to restore the adult party to the position he or she held before the contract was made, right? And this court might hold a minor responsible for damage, any ordinary wear and tear, and any depreciation of goods that minor used. prior to this affirmance, right? So again, if you're gonna encounter this kind of question in the midterm exam, right? It should be like that. Just think through the question, the scenario, and give me the very brief and short answer with the laws or the principle that you're going to use and to apply to the case. What is the result and what is your rationale? Okay, I already shared that in Iraq before, right? So good, thank you. How about number two? Number two should be very easy. So how do we call? How do we name? Use ND's act in case number one in A scenario. In scenario A. What is the legal term? What is the legal term that we should use? The one that we have just discussed. That we should use in A and B. What ND actually did generally in this case? They had something in common, right? A and B of ND's act. If you had to call ND's act, give ND's act a name, a legal term, what would it be? What would it be, guys? What ND actually did with the contract? He ratify. Okay, ND actually ratified a contract. And what Andy did in scenario A is what? Did he do it? Did he do it clearly? Like obviously everyone knew that. Lisa knew that. Lisa, is there any way that Lisa misunderstood it? This one I just mentioned, right? Expressed. Or not. Yep, we can use expressed ratification, and this one is implied ratification. So again, in scenario A, Andy actually expressly ratified the contract, and in scenario B, he has impliedly ratified the contract. So in this, if you were asked to give the name, or you, how can I say, use a legal term to define, to label the act of Andy, then you can either use express ratification or implied ratification would be the perfect answer. However, you can say that he expressly ratified, or he expressly implied. He impliedly ratified would be fine. Okay. Any questions for this part? Okay, otherwise, let's continue. The next one could be parents' liability, right? This is very clear and straightforward. So generally, parents has an obligation to provide food, clothing, shelter, and any necessaries of life for their minor children. Okay? And so they are liable for their children's contract for necessaries of life, right? If they have not adequately provided such item. Such items, okay? And this is where we use the word emancipation, right? So the duty of the parents, right, terminates if a minor becomes emancipated, right? What does it mean by that? We explained it before. So there are certain factors for a court to consider if a minor is emancipated, like either by getting married or setting a separate household or joining the military. So those are some of the examples. Of course, each situation is examined on its merits. Okay. So when we say parents' liability, okay. And necessaries. So the minor liability for necessaries. Okay. So if a minor enter into a contract for necessaries, they may disaffirm the contract but remains liable for reasonable value of goods. Right? What are necessaries again? Food, clothing, shelter, and medical services. And what is necessary for one minor may be a luxury for another. So depending on the minor's customary living standard. So the contract for necessaries are enforceable only to the level of value needed to maintain the minor's standard of living. Okay. So for example, if you buy a bottle of water, and if I use the minor and I buys a bottle of water at the price of 100 Vietnam dong, 100,000. So and he wants to disaffirm it, but he used it already. He can disaffirm and get back for example, the water, the levy, for example, Aquafina, let's say, the reasonable price would be only 5,000 Vietnam dong. So he will get back 95, and he have to pay the 5 because like water should be considered as necessaries. Okay. Oh, sorry, I don't know why it's like this. Okay, next one. Right. However, based on the public policies, many states have enacted statutes specifying that some contracts, right, enforceable against minors, right. It means that they cannot use the Infancy Doctrine as a defense, right, or in other words, minors cannot assert the Infancy Doctrine against enforcement of for these contracts. Okay, and some of the contracts are listed on the slide, or if you have a book, you can see that in the book. Okay, next one. We're gonna move to the second group of people that is protected by the law. Mentally incompetent people, right? So the law actually protects people who suffering suffering from substantial mental incapacity from enforcement for a contract of a contract. Okay. And to be relieved a duty under a contract, that person must be legally insane at the time of entering into the contract. So, and this state is called legal insanity. Okay, legal insanity. Can you please read the slide? And it is actually mentioned in the textbook, but please read the slide first and then I will explain more. Okay, so we have two standards concerning contracts of mentally incompetent person. The first one is a judge insane, and another one is insane but not a judge insane. What does it mean by insane? A judge insane. A judge insane declare legally, it means declare legally insane by a proper court or administrative agency. And a court entered into by a person, a judge insane, is void. Which means that no contract actually exists. Okay? Second one, insane but not a judge insane. If a court has not previously judged a person to be mentally incompetent, but the person was incompetent at the time of the contract was formed, then the contract may be voidable. Okay? And it means that when so what does it mean, insane but not a judge insane? It means that the person is insane but not having been a judge insane by a court or an administrative agency. Okay? A contract is voidable if the person did not know he or she was entering into the contract or lacked mental capacity to comprehend its nature, purpose, and consequences. And such in such situations, the contract is voidable, right? At the option of the mentally incompetent person, but not at the option of the other party. Okay. So let's look at an example, right? Let's look at an example to illustrate this point. So, A agrees to sell his stock, right? His, I don't know, let's see, Apple stock, company, the stock to B for only half price of the market value, half of the market value. So at the time of the deal, A is actually confused about the purpose and the detail of the transaction, but he has not been declared as incompetent, right? Maybe he does not have, he's a farmer, and maybe B is like an expert in in stock. Okay, so he is very confused about the purpose and the details of the transaction, right? So in this case, right, if the court find that A, okay, did not understand the nature and the consequences of the contract due to a lack of mental capacity, then I can actually avoid the sale, right? So this is an example for insane but not a judge insane. Right. So, however, if a contract enter into by a mentally incompetent person, right, and may be valid if the person had capacity at the time that the contract was formed. Okay, so some people are incompetent due to their age, right, or illness, and they have kind of we call lucid interval. Right, which means that there are some periods they have sufficient intelligence, judgment, and will, and sometimes they don't. So during such intervals, they will be considered as legal capacity to enter into a contract. All right. So in short, for mentally incompetence, mental, how can I say, how many scenarios we can have here for the contracts that enter into by people who are considered as mentally incompetent? How many scenarios that we can have so far, guys, as I mentioned? This is a wrap up. So the contracts can be what, and what. There are three scenarios, right? So if the contract entered or made by mentally incompetent persons, it can be what in terms of validity? A judge insane is but a judge insane. Okay. Yes. No. Thank you. But what I'm asking is, in terms of validity, in terms of contract validity, there are three scenarios if the contract made by mentally incompetent people. I have just discussed that. Now I just asked you to summarize it. So what are they?
So we will have voidable and enforceable contract.
Good. Who say that? Nghe.
Yes.
Okay, good. Yes. So hold on a second. We have void, voidable, and what? Nghe.
Enforceable contract.
Enforceable contract. Valid. Right. So, can you please briefly, when the contract entered into by mentally incompetent person is considered as a void one?
A contract is considered as a void one is when is entered by people who is adjudged insane.
Good. Right. So if the court has declared that a person to be mentally incompetent, right, or a judge insane because the court has declared, right, and has appointed a legal guardian, right, any contract made by the person is void from the outset, right? Good. How about voidable?
Voidable is when the person is insane but not adjudged insane.
Yep. So if the court has not declared a person mentally incompetent, but the person lacks capacity to comprehend the subject matter, the nature, and the consequences of the agreement, then the contract is voidable at the person's option. Okay. And the third one, when it's going to be enforceable or valid?
Is when that person is during a lucid interval.
So if the court has not declared the person mentally incompetent, right, and that person was able to understand the nature and effect of the contract at the time it was formed, then the contract was valid and enforceable. Right, very good. Right. So, thank you. Next one, intoxicated person. We know, right? What does it mean when we say intoxicated? Intoxicated person means means what, everyone? Anyone know? So a person who is considered as an intoxicated person is someone who under the contractual incapacity because they are under the influence of alcohol or drugs to the point of incompetence. Okay. So as the person is normal capacity is or to act or to think is inhibited by alcohol or some other drugs, right? A contract entered into by an intoxicated person can be either voidable or valid. Okay, so first of all, if the person was sufficiently intoxicated to lack mental capacity, then that agreement may be voidable, even if the intoxication was purely voluntary. Okay? And if despite intoxication, the person understood the legal consequences of the agreement, then the contract will be enforceable. Very, very simple. Okay. And how much is considered as how much of drug or alcohol consumed, right, for a person to be considered as legally intoxicated to this from the contract varies from case to case, right? And the factors that are considered include the user physical characteristic and his or her ability to hold intoxicants, okay, like the tolerance of the person. And a person who is from a contract based on intoxication generally must be returned to the status quo, right? And of course, the intoxicated person generally must return the consideration received under the contract to the other party and make restitution that returns the other party to the status quo, right? So you can either disaffirm or ratify the contract, right? So an intoxicated person, after becoming sober, may ratify the contract expressly or impliedly, similar to the way that minor do on reaching majority, right? So let's look at the. So this is pretty very straightforward. But do you have any question for this part? More information can be found in the textbook. So if you have any problems, just let me know. Okay. So maybe let's have a quick break. All right, 15 minutes is let's say 35 right now, and we'll be back at 51. Okay. Let's get back at 51. And Ngày, please help me to ask for the class to confirm, right? If March 18 in the morning, 7 to 10:30 works for you guys, okay?
Okay.
So we let's have a break, and we will get back at in 15 minutes, okay?